The next matter before the court is Felix Maurent versus Foley. And as you're getting settled, please take your time, get settled.
You have to proceed.
You may, well, each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Do you have a plan to reserve time for rebuttal, counsel?
I don't anticipate too much rebuttal. I would like to spend most of my time. I'll reserve 1 minute for rebuttal.
Very good, thank you.
If the court has questions.
No problem at all, that's fine. I will be keeping track of your time. I will try to let you know when you're down to about a minute.
Okay.
The arguments are being recorded, so please make sure you introduce yourself.
Yeah,
Please try to stay behind the podium so that you can be picked up by the recording, and please speak in a normal voice so we can hear you. I don't know if this case is necessarily relevant, but if you do have the need to use the names of any children, minors, and victims, please make sure you refer to them by initials rather than their actual names. And we have read your brief and are ready to proceed whenever you are.
May it please the court, I'm Bill Lamb. I represent the warden in this case. A number of years ago, an old lawyer told me that there are two things you have to know before you decide any case. One is, who's your client? And two is, what's the forum? Well, the problem here is we're in the wrong forum. It's that basic. And an indication of the misapprehension of the Court of Common Pleas as to the forum comes from the Court of Common Pleas own order on the second page. I've cited the principal rules, the habeas rules in my brief. I would like to illustrate those rules based upon what I perceive to be a misapprehension in the Court of Common Pleas order. At one point in the order of the Court of Common Pleas, they say, petitioner has proved that there is a clear duty on the part of respondent warden to release Mr. Warden, Mr. Maurent. That language, clear legal duty, is not in habeas. It might be in mandamus, it might be in procedendo, but it's not in habeas. There's no clear legal duty to release a prisoner based upon a sentencing dispute. The cases are legion in the Ohio Supreme Court that sentencing is not recognizable. Therefore, that's one example of where I submit that the Court of Common Pleas misapprehended the forum. The second one is even a little more interesting. It says there's no adequate remedy in the ordinary course of law, according to the Court of Common Pleas. That's not the rule in habeas. The rule in habeas is that if a petitioner has or had an adequate remedy in law, they don't get habeas relief. So at this point, it's completely irrelevant that there's no adequate remedy for this particular stale error.
Sir, I want to raise something that wasn't raised in the briefs, and that is that the petition for writ of habeas corpus must have an institutional account that has individualized months of account balances.
So, talking about money or time.
I'm sorry?
Excuse me, Your Honor. Balances suggest to me money. I'm not sure.
6-month accounting and individual, and the accounting is supposed to have individual lump sums for each month. We have a case, State Ex Rel Poe versus Lanzinger, and yes, that's me, where if you don't conform with that strictly, that it's non-compliance and warrants non-compliant and warrants dismissal petition. Do you think that's an issue here?
No, I did not raise that.
You did not raise it, but do you think it's an issue anyway?
I don't think it's an issue.
Okay.
The problem here goes much deeper than that. The problem here is you cannot immediately release a prisoner on a sentencing dispute. You cannot immediately release a prisoner if the prisoner had an adequate remedy, whether they have availed themselves of it or not, in the ordinary course of law. I could actually sit down and say I'm done now, but I'm not going to do that. I would like to comment on Mr. Maurent's argument, although bearing in mind that really is the heart of the case. I've already said everything I need to say. But in deference to Mr. Maurent and to the court, I'd like to expand a little bit on the argument. understand Mr. Maurent's argument, and counsel for Mr. Maurent may correct me if I'm wrong. He's arguing that counts 14 and 15 should have been considered consecutively to each other. And to make that argument, there are two aspects that I think fail. One is Mr. Maurent wants to add language to page 4 of the actual entry to say to be served consecutively to each other, which language is not in the entry. So Maurent, on the one hand, is arguing, I want to strictly interpret the entry, but on the other hand, when it helps me, I want to add language. And you can't do that. You have to pick one argument or the other. And the other problem with that is Maurent is arguing that the extortion charges, 14 and 15, are consecutive to each other. Is that at the bottom of page 4, as I argued in my brief, and as I argued actually in the transcript in the Court of Common Pleas, the blocks have been checked, which indicate that the trial court went through all of the statutory barriers that apply to get to a case where a count is considered to be consecutive. And once having gone through all those barriers to consecutive sentencing of these particular counts, you have a situation where you have these two counts are sort of out there hanging around. They are now consecutive to something. They're not consecutive to each other. They're consecutive to something else. They're almost like looking for prey.
I'm going to ask you a
They're
question.
consecutive to count 1.
I'm going to also ask you a question on the merits, since we're going there in your brief, and that is, if we get to the merits of this case, as you're arguing them, how is there an adequate remedy at law if the computation changed after the time for an expiration of the appeal on the sentence? Because it sounds like it was computed as 11 years and then later on changed to 13.
No, Your Honor. I said it in my brief. We're not arguing that the ODRC has any power to change the sentence. We're arguing that the sentence 11 years ago was not correctly computed in terms of how the
Right, but somebody computed it to 11 based on the reading of the journal entry.
Your Honor, we have here a sentence that the court issued. Whether the ODRC misunderstood it initially or not does not apply to the question of what is the sentence. Now, I was quite candid in my brief and in my presentation to the Court of Common Pleas. I recognize, yes, there was a misapprehension, administrative misapprehension in the ODRC up until January of 2023, that the sentence was one thing, and then they had a lady look at it in January, and by February, they realized that they had not done a correct calculation. Therefore, they did the correct calculation. The sentence always was not 11 years, but I believe it's 13 years. That's what it was. What the ODRC did or didn't do does not apply in this case. It's not relevant to what the sentence was.
So you're saying there's no ambiguity in the sentence?
As to the entry, now again, remember,
It was an error by the
I'm not saying there's
computation.
no ambiguity in the entry, correct? That counts 14 and 15 are not consecutive to each other. They can't be. They have to be consecutive to count 1. That's Maurent's argument. The other thing is, let me put it this way for Your Honor. Let's suppose we were asked somebody, the man or woman in the street, let's say, what would you think the interpretation is if a court says to Jones, I'm going to sentence you to 5 years for count 1, and Jones, I'm going to sentence you to 5 years for count 2, to be served consecutive, which is exactly what the entry in this case says. Only a lawyer would say that's ambiguous. If you ask anybody else, they say, well, it looks like they're being sentenced together. It must be 10 years. criminal lawyer would say, well, there's no statement of aggregate sentence. It's a pure technicality. This whole case, not only is it the wrong forum, not only is Warren's argument that counts 13 and 14 should be served consecutive, doesn't apply for two reasons. But the third problem is, nobody would say that except us. Nobody would make that technical argument based upon that language except the lawyer. It's ridiculous. I mean, it just does not work. Does the court have any other questions? I would emphasize again that in deference to the court and Mr. Maurent, I'm pointing out some errors in what I think Mr. Maurent's argument will be. But fundamentally, what I've said at the beginning is that rules this case. There cannot be habeas as any kind of sentencing dispute. And secondly, where Maurent has or had an adequate remedy of law, he does not get immediate release in habeas. That really is the ground rules that we're working with here. Thank you.
Thank you. You'll have your full time for rebuttal.
Good afternoon, everyone. Giovanna Bremke on behalf of Mr. Maurent, the appellee in this case. I do want to address right out of the gate Judge Lanzinger's question, and admittedly I wasn't too familiar with that case until I just looked it up. But I understand that relates to the filing fee, is that correct? And the affidavit related to that and waiving the fees. And in that case, I believe it was you that dismissed it right out of the gate. Here, that didn't happen, it wasn't objected to, and not only that, but the judge ratified the finding of indigency when he appointed me to the case upon that finding. I would, again, admittedly, I did not file this petition, I was appointed later, so I don't know whether it was included or not in the record, because it wasn't something that was on my radar, but I would indicate to you, number one, it wasn't brought to the court's attention, it wasn't objected to by the appellant, and it was later ratified about the indigency from the court of the common pleas court. So I would ask that you address the issues in the matter. And in that case, we're left with entry that reads that counts 14 and 15 shall run consecutively. And the dispute comes in about an 8-year sentence versus what would be a 13 under, 11 versus 13. The ODRC had repeatedly calculated this as an 11-year sentence. Even up until the day before Mr. Maurent was going to get released, on February 9th of 2023, they call him down to sign his release paperwork. He fails to sign it because he doesn't want to be put on PRC, that's regardless. But then they say, okay, go back, and they're like, actually you have 2 more years. That is up to the day he's getting released. They calculate it as an 11-year. Now, they're arguing that actually this is a 13 because not only are they going to run consecutive to each other, but consecutive to the 8-year sentence. So that's the discrepancy, is quite frankly the court's entry on 14 and 15. My client filed on March 1st to this petition, and all documents, although I'll get to this, all documents indicate that it was calculated as an 11-year sentence up until his day of release.
So your client's been released, right?
He has.
Does that play into this at all?
Well, I think in general, it's a miscarriage of justice to send him back. He's saying, he's actually well adjusted. Hasn't had any violations on PRC. And, I do think that, again, it's a miscarriage of justice. He's being told he's going to be released on this certain day for 11 years, and then they're going to add 2 years. And I completely dispute that this is a sentencing issue, because what's been repeatedly said is, hey, we're just relitigating a sentencing issue, this would have been a direct appeal issue, but that's not the case, because why would he appeal a sentence that, why would he appeal this issue if the way the reading is, it's ambiguous, which skews in his favor. Appealing the sentence is something the state could have done, and arguably they should have done, because the law indicates that when it's ambiguous, it rules in my client's favor. So to say he should have appealed this issue doesn't make sense, because he's not disputing the actual language of the sentence at all. This is not really, we're not saying, oh, this should have been run consecutive or concurrent, we're disputing he should have been released on this day, because the sentencing entry dictates that that's when the sentence was up. There's also no aggregate sentence in the entry.
That being the case, if we were to simply find your interpretation of the sentencing entry is wrong, he should be sentenced to 13 years, would we have to do anything else to look at anything else?
I'm sorry, what was that?
Well, if, I understand you're saying, look, the whole point of this is look at what the sentencing entry says,
Right.
and that's what we should be following.
Right.
If we think the trial court was wrong, it should have been 13 years and not 11, then wouldn't it, it's one of our responsibility to make a decision that he should go back to jail for 2 years?
Well, this is not just me saying this, there's a law that supports this. So in really towards the end of my brief, we get into the fact that the Attorney General has argued, hey, we gotta look at all these outside factors. There has been other appeals, there's transcripts, there's this or that. This trial court judge could have gotten on the national news and said, I made the wrong decision, it should have been 13 years. It wouldn't have not mattered in this case. What matters is the language in the sentencing entry. There's, Frazier versus Strickrath. That's any ambiguities resolved in my client's favor. There's State versus, I think it's Hall, I may have stopped right, but that's a 9th district decision. Any silence must mean that it's run concurrent. The Morgan versus the Ohio.Pearl, only look at what's journalized in the sentence. State versus Wright, the court made, the statement made it, this is really an important one, because the court later in this case, in State versus Wright, made a statement about the concurrent or consecutive nature of the sentence after it, and the Court of Appeals in that case said, whatever the court's intentions were irrelevant. It's what's in the sentencing entry, and what's in the sentencing entry is an 11-year sentence, not a 13-year sentence. So this isn't just me coming before you saying it should have been 11 years.
Yeah. I'm sorry, you're saying the silence part is that it's not saying what it's running concurrent to. Like they're running with concurrent with each other, but not concurrent to the total sentence, or excuse me, consecutive. Consecutive to each other, but not consecutive with the total sentence.
Correct, it says they should be run consecutive. It's ambiguous. Any ambiguity is construed in favor of Mr. Maurent. And so what the court's intentions were, and what I'm saying is, when you actually look at all these other Court of Appeals decisions, they kind of they don't touch this issue really. But there are some statements made when the case comes back by the trial court judge. That's entirely irrelevant. That's what the law says, and that's what should be followed. What's followed is that the sentence is ambiguous, and what Mr. Maurent's saying is that 14 and 15 shall run consecutively. It's clear that those are to run consecutively to each other. Nowhere does it say they're to run consecutively to count one. It's not, it's very clear that those run consecutive to each other. And if you contrast that with the other language in the sentencing entry where it says this shall run, on the specs it says shall run prior to count one, it doesn't say anything about count one in this part about when it talks about 14 and 15 being run consecutively. Again, there's a lot of discussion about how this is a sentencing issue and this is not the right forum. That is completely, I completely dispute that, because again, we're not saying, hey, you should change this, it shouldn't be run consecutively, or it should be run concurrently. We're not saying change the law, we're saying the way the entry is, he was entitled to be released on February 10th, 2023, and he wasn't. And that's why the Court of Appeal, or that's why the trial court made the decision to release him when they did. Any questions? Okay. Well, I would again ask that you affirm the decision of the trial court, and that you get to the merits of the case, because I don't think that the payment is an issue. It was ratified later by the court by appointing me, finding that he's indigent, and there were documents filed in that regards, again, before I was involved. So I can't say for sure that affidavit wasn't filed, but even if it wasn't, I would say that it doesn't matter, because it wasn't, number one, wasn't raised. Number two, that it was ratified later by the trial court. Thank you.
Just to clarify, the trial court is not the trial court in Lorain County. The trial court was Delaware County 11 years ago.
Right, but the power to grant a writ added from the institution of Lorain is a common pleas court judge
And he does
in
not.
Lorain. And if you argue that there's no remedy at law, then wouldn't he be the right?
He does not have that power. It's flat out, he does not have that power to order immediate release of this petitioner for the two reasons that I stated. To answer your question about consecutive, the exhibits, counts 14 and 15 can only be consecutive to count 1. They can't exist as consecutive counts unless it's almost like that movie, The Aliens. Remember, Sigourney Weaver and the aliens. They have to glom onto something. They don't exist up in the limbo. They have to go to count 1. That's the only count that they can.
Well, if there's two counts, they can be consecutive to each other, correct?
No, Your Honor.
And then they can be concurrent with the other sentence.
No, Your Honor. They cannot be consecutive to each other. And
If it doesn't say that, though.
Henry says to be consecutive. It doesn't say concurrent.
Yeah.
They cannot be consecutive with respect. They cannot be consecutive to each other because the trial court has gone through all this, call it rigmarole if you like, to get over the very statutory barriers to making them consecutive in the first place. So they can't be consecutive to each other. They're hanging out there in the wind separately because they each have gone through those statutory barriers. They have to glom onto something separately, and that has to be count 1. I spent a lot of time talking to the Court of Common Pleas, and more time than I needed to in my brief, trying to rebut this idea of a corrupt motive on the part of the ODRC. And I want to state that again, affirmatively, that any imputation of a corrupt motive by the Ohio Department of Rehabilitation and Correction is completely inappropriate in this case. The record is clear. It was in January that they recalculated the sentence based upon the record they had. There was no corrupt motive. Mr. Maurent perceives it otherwise, but his perception is not accurate. And I believe that's all I have to say. Thank you.
Thank you. And thank you both for your presentation today. The court will take the matter under advisement, issue a decision in due course. The clerk of court will mail a copy of that decision to you when it's released, and it also will be released to the High Supreme